Additional comments, Ms. Kroll.
I appreciate Ms. Rose's concern for student safety, and I share that concern. The statistic I know from the Trevor Project is that LGBTQ students, of those students, 35% of them have suicidal ideation. So for me, this is a student safety issue on the other side. By not having this language, we are putting students at risk. I do have a question for staff, though, about the striking of, in line 7, educational and employment. Why you're recommending that we make this language so broad as to potentially open it up to some of the things Ms. Rose mentioned.
Sure, I can answer that if that's okay. So we never had a Chapter 1 until about 3 years ago. And some districts across the country don't even have a Chapter 1. It is an aspirational, inspirational chapter, philosophical foundation, some people call it. So staff, in line with conversations with L&P about the establishment of that chapter, made that policy broader. And so we said, in other policies, there's a specific area of operations that it addresses very clearly and connects to law and so forth that address those areas. So in employment, for example, harassment, bullying policies, and so forth. But this one was more of that philosophical, foundational kind of policy, and so we broadened the language. We could have, alternatively, we could have added other categories in terms of, oh, it applies to staff, it applies to employment decisions, it impacts students, etc. But instead, we decided to remove the language to make it broader.
Additional comments? Mr. Hornberger.
Yeah, just can you help, staff, can you remind us the genesis of the protected class language that exists in our current policy? Where does that come from? And then, because I would assume that's all the language in black on the proposal, and then the new language is in red. What is, can you tell us a little bit about where that comes from, the list of protected classes?
Yes, the race, color, sex comes from, and pregnancy comes from federal law. There's also state law that reflects the same categories. State law refers also to childbirth and related medical conditions and marital status. Federal law refers to another law, separate law, refers to age. National origin is also under Title VI, and Title VII. Title VII is the section that applies these categories to employment. Disability is under the Americans with Disability Act, and all of these categories are also captured under 2.2-3900 of the state code. So, you know, the effort here originally, as well as genetic information that comes from a federal law, was to just simply to capture those categories and to establish that for anyone who cares to know that Loudoun County Public Schools does not discriminate. I would say, however, that you won't find the word discriminate in this particular policy. So, you know, we have a separate policy dealing with employment equal opportunity that does say we do not discriminate against these classifications. And so that fulfills the requirement for notice in an employment situation. But this particular policy is kind of being handled separate from that one, and it's not really specifically addressing discrimination. It's setting out, as Dr. Richards pointed out, a more of a altruistic kind of statement of philosophy, which could present problems in the implementation because, you know, I would say generally, when any kind of policy is changed, staff is looking to make sure that implementation matches what the policy is saying. Now, this one is not, you know, technically a non-discrimination policy, but it does address equal opportunity. So we would have to look at, you know, our current practices and see how that compares to what the directive is in this particular policy, even though it's not specifically a non-discrimination policy.
Okay, so part of my understanding when we looked at the employment policy in the last 2 years was that the protected class language, anti-discrimination protected class language specifically came from state and federal law. And I heard you say that again. And I think the ancestry and genetic information are kind of more recent adds in that regard, correct?
Well, sexual orientation, or what?
No, I said ancestry and genetic information. Those are more recent.
Genetic information was the most recent federal change, and national origin has an ancestry or
component.
kind of the same thing. They have been in federal law for quite some time.
Okay. Is sexual orientation and gender identity in state or federal law currently as protected classes?
Okay. Under state code, sexual orientation and gender identity are not specifically in the code, but the governor has an executive order that's only applicable to state employees that includes those terms under state law.
Okay. All right. And then when we looked at the employment, I mean, this does seems to be an overarching statement. When we looked at and so I know that we are looking at the employment policy, we're specific to the employment component of this. We added significant language about merit-based. Our employment decisions are more merit-based. That's the positive statement. And I guess for any staff, have we had any complaints about discrimination related to sexual orientation or gender identity in the last 2 years related to our modified policy?
I'm not aware of any. I'd have to review that.
Because I'd like to know. I mean, because my understanding with the employment policy, we've heard speakers speak about, safety of employment here. And our employment decisions are supposed to be made based on our revised policy, our merit-based. And if any of our employees feel that they are being discriminated against for something other than merit, please speak up. Lodge a complaint. We need to be able to see what is actually happening, not from the boardroom and speaking about policy language, but actually about practice. What are those issues that we're encountering that that we're not getting remedied? The same thing I would say is true in our dealing with children and our students. If there are discrimination issues in that and that are bullying, that are effectively bullying, and our current policies are not addressing those, or better yet, our current practices are not actually addressing them. That's what we need. I think that's the key to addressing this, whether we put it in the policy or not, which from my perspective is a change in the posture of the school division and school divisions in general, that historically this specific prescription language comes directly out of state and federal law. And it has processes and history about how that is implemented across either the nation or the state, and how it's interpreted in the courts, which right now, these two, whether we like it or not, the sexual orientation and gender identity is not clear in either the courts, the federal government, or the states. It is still in flux. And if we as a school division, and I know that there was a recent attorney general position that took a more broad view about the Constitution and school board's authority, but that actually was different than what 5 or 6 different attorney generals prior to that had taken in regards to whether or not a local school board could implement it. Now, what we've seen since is that several school divisions have implemented or included this language or added it too. So, and from what I know, they haven't been successfully challenged in that regard yet. So I guess we could say, okay, well then school divisions can. But then the question is, should they? And what are the implications of that? And I'm not clear about what the implications are. When it deals with I'm not sure how Loudoun County Public Schools is going to deal with the issue of gender in sports and gender identity in sports. how we're going to deal with the bathrooms issue, how we're going to deal with other kinds of issues as it relates to student protection and interpretation of this. And we'd be flying solo by putting it in there because we don't have state or federal legislation or courts that give us an idea of how that's interpreted and how that needs to be played out in a local school division context. Again, the issue of whether students feel safe, whether they feel discriminated against, that is a huge issue, but that is a bullying issue, and it needs to be dealt with as a bullying issue, and that shouldn't be tolerated. And if we need to strengthen that language, then let's strengthen that language. If I think the same thing was true with our employment policies. If an employee is being discriminated against for anything other than the work that they do in the school division, that's wrong. We can't stand for that, and I don't think our current policy would allow for that. But then those complaints, where those situations occur, need to be brought up. They need to be lodged because we have a policy that would protect them in that case for all of those different things, anything related that's not related to merit. So these are my concerns. I'm not sure what the unintended consequences or the intended consequences, frankly, of adding these protected classes to a policy, an overarching policy or any policy, because those protected classes were well defined in state, federal law, and or in legal jurisprudence. And I understand that I think it's more of in many ways, it doesn't have teeth. What has teeth is how it's implemented on the ground. And that's where I'm more concerned. And if that is indeed happening in our school division, we should be seeing those complaints. We should be dealing with those situations. And I'd ask our staff, how do we deal with the LGBTQ issues in our schools with our students currently? What is our posture as a school division in dealing with LGBTQ issues?
Can you tell me more what you're looking for? What do you mean? What is?
Well, we've heard students come and talk about their concerns about being ridiculed or their teachers or staff in the school division not coming to their assistance and stopping bullying. So I'm curious, what is the school division's posture and what is its practice and what should it be its practice as it relates to bullying of LGBTQ students or staff?
So we do not want to accept or tolerate bullying regardless of the characteristic that it's intended to address. And so if there are concerns, they should at first be addressed at the school level. And then if they're not addressed completely at the school level, they should be addressed at the division level, for example, with a level director within the Department of Instruction or with the director of school administration.
And have the issues that have occurred been addressed at those levels? I mean, where do they typically end? Do any of them end on your desk or in cabinet level? Or are they addressed typically at the lower level through accommodation or resolution, some sort of resolution?
So would be happy to pull additional information from directors in the Director of School Administration in terms of additional information pertaining to that.
Ms. Turgeon.